Contracts. A contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Another definition of contract, ascribed to Sanchez-Roman, is as follows. It is a juridical convention manifested in legal form, by virtue of which two or more persons bind themselves in favor of another, or others, or reciprocally, to the fulfillment of the prestation to give, to do, or not to do. Stages. The Supreme Court observed that contracts undergo 3 stages. 1. Negotiation. This covers the period from the time the prospective contracting parties indicate interest in the contract to the time the contract is concluded or perfected. 2. Perfection. This takes place upon the concurrence of the essential elements of the contract. 3. Consummation. This begins when the parties perform their respective undertaking under the contract, culminating in the extinguishment of the same contract. There is no liability for damages for acts or omission during the negotiation stage. However, while there is no liability ex contractu, they may be liability for quasi-delict or abuse of right, depending on the circumstances. Kinds of contracts. A. As to how it is perfected. Example, consensual, formal, or real. B. As to whether or not there is defect, like valid, voidable, unenforceable, rescissible, and void. C. As to the degree of independence or dependence, like principal, accessory, and preparatory. D. As to whether or not obligations are fulfilled, like executory and executed. E. As to whether or not a name is given by law, like nominate and innominate. F. As to the nature of consideration, like gratuitous, onerous, and remuneratory. Principal. This contract may exist alone, even without the presence of any other contract. Example, contract of sale. Accessory. This contract cannot exist without the presence or existence of another contract. Example, mortgage, which cannot exist alone. There must be another contract like a loan to be secured by the mortgage. Preparatory. This contract is entered into so that other contracts can be entered into or in anticipation of another contract. Example, agency to sell. This is in anticipation of the contract of sale that may be entered into. Executed. The obligations are fulfilled upon entering into the contract. Executory. The obligations will be performed after the contract is entered into. Nominate. A name is given under the law. Example, loan, sale, agency. Innominate. No name is given by law. Inanimate contracts. Under Article 1307, the different kinds of inanimate contracts are as follows. 1. Duot des. I give so that you may give. Example, goods will be given in exchange for goods. 2. Duot facies. I give so that you may do. Example, goods will be delivered in exchange for services that will be performed by the other party. 3. Facio ut facies. I will do so that you may do. Example, services will be performed in exchange for the performance of another service by the other. 4. Facio ut des. I will do so that you may give. Example, services will be performed so that the other may give certain goods. Rules that apply to innominate contracts. First, the agreement or stipulation between the parties. Second, the provisions of the new Civil Code on obligations and contracts. Third, provisions on nominate contracts that may be applied by analogy. Fourth, customs of the place. Basic characteristics of contracts. 1. Autonomy. 2. Mutuality. 3. Relativity. 4. Obligatoriness. Obligatoriness. The contract is 1. The law between the parties, and 2. Must be complied with in good faith. The contract itself governs the relationship of the parties, and they are required to perform the acts required in the contract and to follow the terms and conditions stated therein. The following rules logically flow from such rule. 1. One party cannot unilaterally change the provisions of the contract without the consent of the other. 2. The parties cannot refuse to comply with the obligations stated in the contract. 3. Any party can file a case in court if the other party will fail to perform his obligation. 4. The court where the case was filed by a party to the contract cannot change the provisions of the contract. It can interpret the contract, but it cannot replace what was agreed upon by the parties. Autonomy of contracts. Under Article 1306, the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. Even the courts cannot make a contract for the parties. Neither abstract justice nor rule of liberal construction justifies the creation of contract for the parties which they did not make themselves, for the imposition upon one party to a contract of an obligation not assumed. Limitations. The parties must not agree on stipulations that are contrary to 1. Law. 2. Morals. 3. Good customs. 4. Public order. Or 5. Public policy. The contract should not be contrary to law. However, the law referred to here are mandatory and prohibitory laws. Autonomy does not mean that the law will be disregarded. The provisions of positive law, which regulate contracts, are deemed written therein, and shall limit and govern the relationship between the parties. The Constitution is the paramount, fundamental, and supreme law, and is therefore written in every statute and contract. Morals and good customs. This refers to standards of right and wrong and decency acknowledged by the society. According to the Code Commission, morals and good customs overlap each other, but sometimes they do not. Public order. What is being considered is the public weal, peace, safety, and health of the community. Public policy. A contract is against public policy if it has tendency to injure the public, is against public good, or contravenes some established interest of society, or is inconsistent with sound policy and good morals, or tends clearly to undermine the security of individual rights. Examples: contracts that exempt those guilty of malice from liability. 2. An agreement not to report the commission of crimes. Illustration: A. A consistent scholar and honor student for 3 years in M University, and he enjoyed free tuition privileges. In his 4th year, he decided to study in a university in Davao, as his father died, and he had to stay with his mother. He needed the transcripts of his records in M University, but M University refused to issue them until he had refunded the whole amount of tuition fees given to him for 3 years. Alleging that he signed the agreement beforehand and waiving his right to transfer to another university without having refunded the cash equivalent of his scholarship, A was forced to refund the amount as he did not want to be late for his enrollment in the Davao University. Later, he sued for its return. Can A recover the amount he refunded to M University? Reason for the answer, asked in 1978 bar. Answer: yes. A can recover the amount from M University. The provision prohibiting transfer of the student if the cash equivalent of the student's scholarship is not paid is void for being contrary to public morals and public policy. Scholarships are meant as a recognition of merit and not a business scheme of a school. Cui versus Aureliana University, 2nd Scra, 205, 1961. Mutuality and obligatoriness of contracts under Article 1308 to 1310. Consistent with obligatory nature and the principle of mutuality of contracts. 1. Contracts bind all parties, and 2. The validity and compliance of contracts cannot be left to the will of one of the parties. Thus, one of the parties cannot claim that the contract is binding on him and not to the other. One party cannot change his mind and withdraw from the contract without the consent of the other. As in 2012 bar. Manresa believes that Article 1308 is based, firstly, on the principle that obligations arising from contracts have the force of law between the parties, and secondly, that there must be mutuality between the parties based on their essential equality. Because of their essential equality, it is repugnant to have one party be bound by the contract, leaving the other party to be free therefrom. Will of party or third person. The basic rules are as follows. 1. If compliance of the contract is left to the will of only of the debtor, the contract is void. Example, an agreement that Mr. A will deliver a sack of rice to Mr. B if Mr. A wants to deliver is void. 2. If compliance of the contract is left to the will of a third person, the contract is valid. If the compliance is left to the will of a third party, it is necessary that 1. The decision of the third party must be made known to both parties, and 2. The decision of the third person must not be inequitable. Relativity of contracts. Relativity of contracts means that contracts take effect only between 1. The parties, 2. Assigns, the person to whom the contract or rights and obligations are transferred, and 3. Heirs, persons who will inherit in case of death of the parties. As in 2011 and 2012 bar. Contracts will not generally take effect as to third persons who are not members of any of the 3 groups. The contract will not take effect between the assigns and heirs if the contract is not transmissible because of 1. Nature of the contract, 2. Stipulation, or 3. By provision of law. This includes cases when the act stipulated to be performed require the exercise of special knowledge, genius, skill, taste, ability, experience, judgment, discretion, integrity, or other personal qualifications, and therefore the obligation is personal in nature and is terminated upon the death of the obligor. Example, the contract whereby a famous painter will make a painting cannot be transferred if the intention is that only the famous painter will perform the act to be done. Exceptions to relativity. It is a fundamental axiom in the law of contracts that a person who is not a party to the agreement should not be affected thereby. Third persons will be affected by the contract in the following cases. 1. If there is a stipulation in favor of third persons. 2. If there is a law that extends benefits under the contract to third person. 3. If the contract is intended to defraud the creditor. In this case, rescission under Articles 1177 and 1381 are available to third persons who are defrauded. 4. If the third person files subrogatory action or rescissory action. 5. Where real rights are created in the contract. Example, a real estate mortgage that is registered with the Register of Deeds is binding even on third person. Negotiatorium gesture. Stipulation in favor of third persons. Requisites. The second paragraph of Article 1311 restates the rule on contracts por otro. Stipulation in favor of third persons 1991 and 2002 bar. The following requisites must concur before these rules can be made to apply and before the stipulation can be considered binding. 1. The contract contains a stipulation in favor of a third person. 2. The stipulation in favor of third person must be only part and not the whole of the contract. 3. The contracting parties clearly and deliberately conferred a favor upon the third person and not merely incidental benefit or interest. 4th, the favorable stipulation must not be compensated by any obligation. And 5th, the third person must communicate his acceptance to the obligor before its revocation. And number 6, the contracting parties are not legal representatives or duly authorized by the third person to enter into the contract that gives the latter benefit. Illustration. Mr. X, the owner of a passenger jeepney, entered into a contract with Y Insurance Corporation, whereby the insurer agreed to pay all damages that may result to the vehicle of Mr. X in any accident. The insurance contract also provides that the insurer will pay any damage resulting to any passenger in an accident involving the vehicle of Mr. X. Number 2. XYZ Credit Card Corporation entered into an agreement with X department store whereby the store agreed to honor the credit card of XYZ that may be presented by a customer in case the customer wants to purchase goods on credit. Interference with contracts. Article 1314 embodies a tort called interference with contracts, under which a party to the contract may sue a third person for damages if the said third person causes the other party to violate the provisions of the contract. Requisites. The requisites of the liability for the tort of interference with contracts are as follows. 1. The existence of a valid contract. 2. The third person must be aware of the existence of the contract. And 3. The interference of the third person must be without legal justification or excuse. Example. Mr. A owns a bar and restaurant and he hired Mr. X as a singer for a period of 1 year. When Mr. B, the owner of another bar, learned that Mr. X is very good, he induced Mr. X to terminate the contract without any reason and he entered a contract with him, Mr. B. Perfection of contracts. Article 1315 and 1316. Perfection signifies the birth of a contract. That is, when all essential elements of a contract concur. As to how contracts are perfected, they may be classified into 1. Consensual contracts, 2. Real contracts, or 3. Formal contracts. Consensual contracts are perfected by mere consent or upon the meeting of minds upon the object and consideration of the contract. Example, contract of sale. Real contracts are perfected only upon delivery. Example, loan, deposit, pledge, or comodatum. 3. Formal or solemn contracts are perfected only upon execution or preparation of certain documents or other formalities. Example, donation of real property which must be in a public instrument. 2. Agency to sell real property which must be in writing. Note: contract for the construction of a building is not a solemn contract. 2012 bar. The parties to the contract may personally enter into the contract or may ask somebody else to represent them. In addition, the court may also in certain cases appoint a person who may represent a party to the contract, as in the case of appointment of guardians. The contract is unenforceable if a person enters a contract without authority of the supposed principal. The contract is not unenforceable if the supposed principal ratified it. Examples: 1. Mr. X sold the watch of Mr. B to Mr. Y without the authority of Mr. Y. Later, Mr. Y signed a special power of attorney authorizing Mr. X to sell his watch. Number 2. In the first example, there is implied ratification if after learning about the unauthorized sale, Mr. Y accepted from Mr. X the proceeds of the sale paid by Mr. B. Essential requisites of contracts. There is no contract unless the following requisites concur. 1. Consent of the contracting parties. 2. Object certain which is the subject matter of the contract. 3. Cause of the obligation which is established. Additional elements. For real contracts, delivery is also an essential element. On the other hand, formal contracts additional require certain formalities to be valid and binding. B. There are at least two parties to a contract because there can be no meeting of minds if only one person is involved. However, two parties may be represented by one person, as in the case where they are represented by one agent. Kinds of requisites. There are three kinds of requisites. 1. Essential elements, 2. Natural elements, and 3. Accidental elements. Essential elements are those enumerated under Article 1318. There is no contract unless the essential elements concur. Natural elements are those that accompany the contract based on their nature. Natural elements are presumed by law to exist. Example, implied warranty in a contract of sale. Accidental elements are those that exist only because of the agreement of the parties. Consent is manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Casting. It is the meeting of two declarations of will, which coming from two diverse subjects are directed to a common end and are united. Sanchez-Roman. The agreement of the will of a contracting party with that of another or others with respect to the same subject and terms of the contract. Elements of consent. Castan enumerates the following elements of consent: plurality of parties, capacity of the parties. 3. Will, which must be intelligent or conscious, spontaneous, and free. 4. Declaration or manifestation which may be either express or implied. And 5. Agreement of the internal and the declared will. Offer and acceptance. Implicit from the foregoing elements are two basic elements for the existence of contracts, to wit: 1. Offer, and 2. Acceptance. A. Offer. An offer is a manifestation of willingness to enter into a bargain, so made as to justify another person is understanding that his assent to that bargain is invited and will conclude it. The essential requisites of an offer are: 1. The offer must purport to create legal liabilities that are legally enforceable. 2. There must be a real intention to assume liability. 3. It must be intended of itself to create legal relations on acceptance. 4. It must be complete in terms. And 5. It must be definite. Acceptance means signification of conformity with all the terms of the offer. The essential elements of acceptance are: the acceptance must be unqualified and unconditional. 2. It must be directed to the offerer. 3. It must be made with the intention to bound. 4. It must be made within the proper time. And 5. The acceptance must be communicated to and learned by the offerer. Counteroffer. There is no perfected contract if the offeree will not accept but will just make a counteroffer. If the acceptance is qualified, the same is considered a counteroffer. Examples: Mr. A communicated to Mr. B that he is offering to sell his house to the latter. However, Mr. A has not yet fixed the price. There is no effective offer yet because the offer is incomplete. Number 2. Mr. A offered to sell his dog to Mr. B for $1,000. Mr. B accepted the offer but informed Mr. A that he is only willing to pay $500. The acceptance of B does not result in a contract, because the acceptance is qualified and therefore constitute a mere counteroffer. Advertisements and invitations. Note that the advertisements for bidders are not offers, but mere invitations. Thus, Mr. A published a notice in a newspaper whereby he sought offers for the purchase of his car for the minimum price of $200,000. The notice is not considered a real offer under the Civil Code, but a mere invitation to make an offer. If Mr. B sends a letter to Mr. A stating that he agrees to buy the car of 2,000 pesos, the contract is not perfected yet because Mr. B is deemed to be making an offer only. Mr. A must accept the offer. Cognition theory. When acceptance is effective, the rule is that the acceptance takes effect from the time the offerer learns about the acceptance. This is known as the cognition theory. If the acceptance is made by letter or telegram, the same is binding on the offerer from the time it, letter or telegram, came to his knowledge. 2. If the offer is made through the agent, the acceptance is effective when the principal or his agent learns about the acceptance. Illustration. Mr. A offered to sell his book to Mr. B for $500 on June 5, 2013. While they were having dinner in a restaurant, Mr. B verbally informed Mr. A on the same date and time that he agrees to buy the book. The acceptance is effective and the contract is perfected because there is meeting of minds with respect to the subject and consideration. 2. Mr. A offered to sell his book to Mr. B for $500 on June 5, 2013. On June 6, 2013, Mr. B sent a letter to Mr. A by mail accepting the offer. The letter was delivered to the house of Mr. A on June 9. Mr. A read the letter on June 10. The contract was perfected on June 10, 2013 because it was on said date that Mr. A learned about the acceptance. 3. Mr. A wants to sell his book, but he has no time to do so. Thus, he hired Mr. C to sell his book. Mr. C offered to sell Mr. A's book to B for $500 on June 5. Mr. B accepted the offer by sending a letter to Mr. C on June 6. Mr. C received and read the letter on June 10. Mr. C informed Mr. A about the acceptance on June 11. The acceptance became effective and the contract was perfected on June 10, when the agent learned about the acceptance. When is an offer ineffective? An offer becomes ineffective or is terminated in the following cases. 1. Upon the death, civil interdiction, insanity, or insolvency of either party before acceptance is conveyed. 2. When a counter-offer is made. 3. When the offerer fixed the time or period acceptance is to be made and the period expired. 4. When the offer is revoked before acceptance, revocation can be made even before the expiration of the time given to accept, so long as there is no consideration distinct from the price. 5. If the person to whom the offer is given rejected the offer. Illustrations. Oh, but before I go ahead and continue, I'm really so sleepy now. Let's take a quick break and make sure that you are subscribed to our channel and hit that bell button for you to get notified for the next audios. I really appreciate it. Thanks. 1. Mr. A offered to sell his book to Mr. B for 500 pesos on June 5, 2013, while they were having dinner in a restaurant. Mr. A informed Mr. B that he has 5 days to accept. Mr. A died on June 6, 2013. Mr. B accepted the offer on June 10 by sending a letter. The acceptance is not effective and the contract is not perfected because the offer became ineffective on June 6, 2013. In the first example, if Mr. A died on June 15 instead of June 6, and he learned about the acceptance of Mr. B on June 12, the contract is perfected. Mr. A offered to sell his book to Mr. B for 500 pesos on June 5, 2013. Mr. A gave Mr. B up to June 10 2013, to accept the offer. On June 26, 2013, Mr. B sent a letter to Mr. A by mail accepting the offer. Mr. A received and read the letter on June 30, 2013. The contract is not perfected because the acceptance was not made within the time stipulated. Another example, Mr. A offered to sell his book to Mr. B for 500 pesos on June 15, 2013. Mr. A gave Mr. B up to June 10, 2013 to accept the offer. On June 7, 2013, Mr. A informed Mr. B that he is revoking the offer. This revocation is effective, and Mr. B can no longer insist on accepting the offer. Mr. A offered to sell his book to Mr. B for 500 on June 5, 2013. Mr. A gave Mr. B up to June 10, 2013 to accept the offer. Mr. B gave Mr. A 10 pesos so that he will not revoke or withdraw the offer up to June 10, 2013. On June 7, Mr. A informed Mr. B that he is revoking the offer. This revocation is not effective and Mr. B can accept the offer up to June 10, 2013. Under Article 1324, the offeror cannot withdraw the offer if the option is founded upon a consideration like the 10 pesos paid by Mr. B. Austin 2013 bar. Capacity to give consent. The age of majority is now 18 years, as provided for under Article 34 of the Family Code, as amended by R.A. 6809. Thus, minors or persons below 18. When a person is 18 years old, he is qualified and responsible for all acts of civil life. 1. If one party is a minor and the other is not, the contract is voidable. 2. If both parties are minors, the contract is unenforceable. If one of the parties is insane at the time the contract was entered, the contract is voidable. Exception: if the insane entered into the contract during a lucid interval, the contract is valid. If one of the parties is deaf-mute who does not know how to write, the contract is also voidable. It is required that the party is 1. Deaf-mute, and 2. The deaf-mute must not know how to write. If the deaf-mute knows how to write, the contract is valid. A contract entered into while in a state of drunkenness or under hypnotic spell is voidable. Married women are not incapacitated to enter into contracts. There is now equality between men and women when it comes to capacity to act. Persons of advanced age or those suffering from physical incapacity are not incapacitated to enter into contracts. Only when such age or infirmity impairs mental faculties to such extent as to prevent him from properly, intelligently, and fairly protecting his property rights, if he is considered incapacitated. Vices of consent. A contract is voidable if consent is vitiated by 1. Mistake, 2. Violence, 3. Intimidation, 4. Undue influence, or 5. Fraud. Vices of consent are circumstances that affect the decision of the party to enter into a contract. The vice may refer to the capacity of a party to understand, like minority, insanity, being deaf-mute who do not know how to write, and other personal circumstances discussed above. The vice may involve the volition of the persons involved, like in cases where violence, fraud, intimidation, and similar circumstances adversely affect the decision to consent. Mistake. Mistake may invalidate consent only if it refers to the substance of the thing which is the object of the contract, or to those conditions which have principally moved one or both parties to enter into the contract. Thus, mistake may involve wrong conception of the thing and a belief in the existence of some circumstances, fact, or even which in reality do not exist. However, mistake as to the identity or qualifications of one of the parties will vitiate consent only when they are the principal causes of the contract. Error must be excusable. Mistake connotes something that is not intentional and one that is not characterized by recklessness. In addition, the error must be excusable. This requirement is contemplated under Article 1333 because under the same provision there is no mistake if the party alleging it know the doubt, contingency, or risk affecting the object of the contract. There will be inexcusable error if the party proceeded even with such knowledge. Exceptions. Article 1332 provides that when one of the parties is unable to read, or if the contract is in a language not understood by him, and mistake or fraud is alleged, the person enforcing the contract must show that the terms thereof have been fully explained to the former. The exceptions are those provided for under Article 1333 because, in effect, there is no opportunity to ascertain the truth in those cases because the party is unable to read, or the contract cannot be understood by him. Mistake of fact and law. The mistake that will vitiate the contract is a mistake of fact, and not generally a mistake of law. The rule is that ignorance of the law excuses no one from compliance therewith. It was also observed by the Code Commission that while mistake of law does not generally vitiate consent, there is a mistake on doubtful questions of law, or the construction or application of law, which is analogous to mistake of fact. Mistake on doubtful questions of law should vitiate consent because the layman should not be accountable for his honest mistake on a doubtful legal issue because even the highest courts are sometimes divided upon difficult legal questions, and one half of the lawyers in all controversies on a legal question are wrong. Mutual error. Under Article 1334, mutual error as to the legal effect of the agreement when the real purpose is frustrated will vitiate consent. The requisites are as follows. 1. There is an error with respect to the effect of the agreement. The error must be mutual or on the part of both parties. And 3. The error must frustrate the real purpose of the parties. Violence and intimidation. These vices of consent may be exercised not only by the parties to the contract, but also by third persons. Violence. It refers to a degree of physical constraint or danger actually inflicted upon a person. Violence will vitiate consent if the following requisites are present. 1. There must be physical force that is of such degree that the victim has no other choice but to comply. 2. The physical force caused the giving of consent. Intimidation. It is the exertion of moral force or compulsion. The danger or constraint is threatened or impending. There is intimidation when one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property, or upon the person or property of his spouse, descendants, or ascendants, to give his consent. Intimidation will vitiate consent if the following requisites are present. 1. The intimidation must be the determining cause of the contract or must have caused the consent to be given. 2. The threatened act must be unjust or unlawful. 3. The threat must be real and serious, there being an evident disproportion between the evil and the resistance which all men can offer, leading to the choice of the contract as the lesser evil. And 4th, it produces a reasonable and well-grounded fear from the fact that the person from whom it comes has the necessary means or ability to inflict the threatened injury. Undue influence. Undue influence refers to any means employed upon a party which, under the circumstances, he could not well resist, and which, under the circumstances, he could well resist, and which controlled his volition and induced him to give his consent to the contract, which otherwise he would not have entered into. Solicitation, importunity, argument, and persuasion do not constitute undue influence. The line between due and undue influence, when drawn, must be with full recognition of the liberty due every person to obey the voice of justice, the dictates of friendship or gratitude, and of benevolence, as well as claims of kindred, and not hindered by personal incapacity or particular regulations to act according to his free choice. The elements of undue influence to be established to justify the cancellation of the instrument are: a person who can be influenced; 2. The fact that improper influence was exerted; and 3. Submission to the overwhelming effect of such unlawful conduct. Confidential relationship may give rise to undue influence. However, for such confidential relationship to give rise to undue influence, the relationship must reflect a dominant, overmastering influence which controls the dependent person. Influence obtained by persuasion, argument, by appeal to affections is not prohibited either in law or morals, and is not obnoxious even in court of equity. Fraud, on the other hand, is employment of insidious words or machinations of one of the contracting parties to induce the other to enter into a contract which, without them, he would not have agreed to. These include false promises, exaggerated expectations or benefits, abuse of confidence, fictitious name, quality, or power. Fraud involves the deliberate intention to cause damage or prejudice, the voluntary execution of wrongful act, or a willful omission, knowing and intending the effects which naturally and necessarily arise from such act or omission. Kinds of fraud. Fraud may either be dolo causante or dolo incidente. Dolo causante are misrepresentations or concealments that are serious and without which the other party will not enter into the agreement. Dolo incidente are misrepresentations or concealments that are not serious in character, and the other party would still have entered into an agreement but under different terms. Requisites of dolo causante. There must be representation or concealment of fact. The party who made the representation or concealment intends to induce the other party to give his consent. 3. The fact concealed or represented is not true. 4. The party who made the representation or concealment was aware of the falsity of the matter represented or concealed. 5. The party who was induced to give his consent relied on the representation or concealment without any fault or negligence. 6. The matter concealed or misrepresented must be material. 7. The other party must give his consent because of the concealment or misrepresentation. And 8. The fraud should not be committed by both parties. Only one party committed the fraud. Illustrations. Mr. X offered to sell a ring to Mr. Y, representing that it is made of gold. Mr. Y believed Mr. X, so he purchased the ring, although it turned out the ring is just gold-plated. Second, Mr. X advertised that the car that he is selling is the best car in the market. This is the usual exaggeration in trade that does not vitiate the consent. Article 1340. A man who relies upon such an affirmation made by a person whose interest might be so obvious as to prompt him to exaggerate the value of the property, does so at his peril, and must take the consequences of his own imprudence. Third, Mr. A sold his car to Mr. B, stating that the car is in good order and condition. This is an expression of opinion, and there will be no fraud if it turns out that the car later developed engine trouble. Article 1341. The conclusion would be different if Mr. A is an expert mechanic and Mr. B relied on their representation. Article 1341. Second paragraph. Simulation. In simulation, the apparent contract is not really desired or intended to produce legal effects, nor in any way alter the juridical situation of the parties. An absolutely simulated contract is void, while a relatively simulated contract is also void, but only if it prejudices third persons and it is for one purpose that is contrary to law, morals, good customs, public order, or public policy. Simulation is defined as the declaration of a fictitious will deliberately made by agreement of the parties in order to produce for purposes of deception the appearances of a juridical act which does not exist or is different from that which was really executed. Simulation takes place when the parties do not really want the contract they executed to produce the legal effects produced by its wordings. Requisites of simulation. 1. An outward declaration of will different from the will of the contracting parties. 2. The false appearance must have been intended by mutual agreement. And 3. The purpose is to deceive third persons. Kinds of simulated contracts. Absolutely simulated contracts. Contracts where the parties do not intend to be bound at all. 2012 bar. Example. Mr. X signed a deed of sale in favor of Mr. Y, although the parties agreed that Mr. X will remain to be the owner. Mr. X just signed the deed in order to make his property out of reach of the Bureau of Internal Revenue. Relatively simulated contracts. The parties intend to be bound, but they conceal their true agreement. Example, Mr. X signed a deed of donation in favor of Mr. Y, although he really received an amount in return. The true agreement, in this case, is a sale. Object. The object of the contract refers to the thing or right which is the subject matter of the contract. Things that may be the object of the contract may be tangible or intangible. Therefore, the object may be intangible things which include rights. The term thing referred to here is synonymous with the term property under the new civil code because only property may be or is subject to appropriation. The provisions of the new civil code make implicit the following requisites. 1. The thing or service must be within the commerce of man. 2. The thing or service must not be contrary to law, morals, good customs, public policy, or public order. 3. The thing or service must be possible. And 4th, the thing or service must be determinate, or at least determinable. What do you mean by outside the commerce of man? Things and services are outside the commerce of man if they cannot be appropriated or they are incapable of private ownership, or if they are intransmissible. The term outside the commerce of man includes things that are not licit or things that are contrary to law, moral, good customs, public policy, and public order. Manresa enumerates those included in things or services outside the commerce of man. 1. Services that presuppose degradation or absolute submission of the person rendering the services, sacrificing his liberty or independence, or beliefs, or equality and dignity. Example, contract for perpetual servitude. 2. Personal rights. Example, marital rights and right of support. 3. Honorary rights such as titles and distinctions. 4th, political rights. Example, the right to vote. 5th, public office. 6. Things withdrawn from commerce by law or by public policy. Examples, property of public dominion, prohibited drugs, and nuclear weapon. 7. Things not susceptible of exclusive ownership. Example, the water in the ocean in its entirety and the air around us. What are future things and future inheritance? Future things, these refer to all things that do not belong to the party, like a seller or a donor. These include things that are expected to increase in the future, like the expected harvest of rice that were planted by the farmer, or things that belong to a third person. Future inheritance, herentia futura, is a contingent universality or complex of property rights and obligations that are passed to the heirs upon the death of the grantor. This includes any property or right not in existence or capable of determination at the time of the contract that a person may in the future acquire by succession. The concept of future inheritance presupposes that the person who previously owns the property has not yet died. Before such death, there is pure expectancy, and the property which may exist at time of death cannot be determined. After such death, the property that is part of the inheritance is actually vested in the heirs of the deceased. No contract may be entered into upon future inheritance except in cases expressly authorized by law. The reason for this rule is that if a man were to be allowed to bargain away all the property he expects to leave behind, example, his estate as a whole, he would practically remain without any incentive to practice thrift and frugality, or to conserve and invest his earnings in property. For the inheritance to be considered future, the succession must not have been opened at the time of the contract. A contract may be classified as a contract upon future inheritance prohibited under the second paragraph of Article 1347, where the following requisites concur. 2012 bar. that the succession has not yet been opened, that the object of the contract forms part of the inheritance, and that the promisor has, with respect to the object, an expectancy of a right which is purely hereditary in nature. What are impossible objects? The object is impossible if the same cannot be done or performed under the law or according to the course of nature. Impossibility are classified into the following kinds. Physical impossibility, one that is contrary to the course of nature, which may be 1. Absolute, or that which is impossible in any case. Example, Mr. A will stay in the sun. Or 2. Relative to that which is impossible because of certain circumstances. Example, for Mr. A to receive a thing, Mr. A is already dead. Number 2, practical impossibility. The act can be done, but only at an excessive or unreasonable cost. Example, when a ship is so damaged, such that although it can be repaired, the cost is not worth the effort. 3. Legal or judicial impossibility. When a rule of law makes it impossible to do. Example, Mr. A, minor, will be obliged to prepare a last will and testament. 4. Logical impossibility. One that is contrary to the nature of the transaction. Example, A gives a property to B for his benefit on the condition that Mr. B will immediately transfer the same property to C. 5. Original impossibility or ab initio impossibility. The object is impossible from the beginning. 6. Subsequent impossibility or ex post facto impossibility. The object becomes impossible by matters subsequent. What is determinate and determinable? Determinate. The law requires that the thing must be determinate as to its kind and quantity. Example, the object is determinate if it's a dog of a particular breed because the kind and quantity is determinate. 2. The object is not determinate if what was mentioned only is animals. Determinable. The quantity of the thing is determinable if the same can be determined without that need to enter into an agreement. For example, the quantity is determinable if it can be determined by mathematical computation using given items. Quality. If the quality is not stated, the rule under Article 1246 should be applied. What is cause or consideration? Cause or consideration of a contract is the essential or more proximate purpose which the contracting party have in view at the time of the contract. Cause or consideration is the reason that impels a party to assume an obligation on their contract. Stated differently, consideration is the why of the contract, the essential reason which moves the contracting parties to enter into the contract. The following results into a void or non-existent contract. 1. Where there is no cause. Note, however, that the presumption is that there is a cause, so that person who claims that there is no cause must prove such absence. 2. Where the cause is not lawful, that is, the cause is contrary to law, morals, good customs, public order, or public policy. 3. If there is false cause, exception, when it can be established that there is another cause. Example, Mr. A signed a deed of absolute sale, which states that he is selling his watch to Mr. B for 1,000. The cause is false if there is really no agreement to pay money. However, it can be established that there is another cause like pure liberality, which will make the contract a donation, or that the obligation of Mr. B is to deliver other goods, which will make the contract barter. Types of contracts and their causes. Onerous contracts. The cause is understood to be, for each contracting party, the prostration or promise of a thing or service by the other. Example, sale where the consideration for the seller is the promise to pay the price, while the consideration for the buyer is the delivery of the thing. Remuneratory contracts. The cause is the service or benefit, which is remunerated. Remuneratory contract is one where a party gives something to another because of some service rendered or benefit given by one party to the other where such service or benefit was not due as a legal obligation. Example, Mr. A took care of Miss B when the latter was sick. Later, Mr. B delivered an amount to Mr. A in consideration of the service. The consideration is the act of taking care of Mr. B. Gratuitous contracts or contracts of pure beneficence. The mere liberality of the benefactor is the cause. Example, donation where the mere liberality of the donor is the cause. Cause distinguished from motive. Cause is the essential reason of the contract, while motive is the private reason of the contracting party in entering into the contract. The distinction are as follows. Under cause, the legal reason that impels one to enter into the obligation. Motive, the private, personal, or psychological inducement of the party to enter into the contract. Number 2. Cause. The cause is the same for certain types of contract, example, sale, lease, etc. For motive, even if the same contract is involved, the motive may be different. 3. Both parties are aware of the cause. Motive. The motive of one party need not be known to the other. 4th. Cause is an essential element of the contract, while motive is not an essential element of the contract. What is inadequacy or lesion? Inadequacy of the consideration, also known as lesion, by itself will not make the contract effective. The inadequacy of the consideration will adversely affect the contract only if it is coupled with other grounds like fraud, mistake, or undue influence. Example, Mr. A sold a watch to Mr. B for $500. The value of the watch is $1,000. The contract is not defective. Selling a thing at a bargain will not invalidate or make the contract defective. It is also important to observe that inadequacy of the cause is different from partial performance. In partial performance, the cause may be inadequate, but it was partially delivered or complied with.